Welcome and thank you for standing by. At this time, all participants are in listen-only mode until the question and answer session. At that point, to ask a question, please press star followed by 1. This call is being recorded. If you have any objections, you may disconnect at this point. Now we'll turn the meeting over to Mr. Vora. Mr. Vora, you may begin.
Thank you. Good afternoon, everybody. My name is Akhil Vora. I'm Director of Strategic Initiatives at the White House Initiative on Asian Americans and Pacific Islanders. I'm joined today by Michael Hawes, who is the Statistical Privacy Advisor at the Office of the Chief Privacy Officer here at the U.S. Department of Education. We welcome you to our second webinar on privacy and Ferpa issues, focused on data sharing and research under Ferpa. We are proud to be bringing you this event alongside our partner, the National Commission on Asian American and Pacific Islander Research and Education. Again, this is a follow-up to our webinar that we had last year. So today we'll be focused a little bit more on what actually can we do in terms of sharing data and research under FERPA. Eager to hear your questions and comments, but we'll be saving those until the end of the webinar. We'll be asking you to, again, hit star 1 if you have any additional questions. With that, just a reminder, everybody is on mute at this time. With that, I will turn it over to Michael.
Great, thank you, Akhil. So today, I'm going to talk briefly about the Family Educational Rights and Privacy Act and how you can disclose or share student personally identifiable information in support of research and evaluations of education programs. So just a quick overview of what we're going to cover, a brief synopsis of what FERPA is and how it relates to student privacy. I'll go through the basics of data sharing for research under FERPA, both when and how you can share raw identifiable data, and also how you can report your results from those analyses and or share de-identified data with the public. I'll cover a brief overview of some of the technical assistance resources that we have available on this and related topics. And then most importantly, we'll have time at the end for questions that you may have about sharing education data for research purposes. So for starters, what is the U.S. Department of Education's role in protecting student privacy? Well, first and foremost, we administer and enforce a number of federal laws governing the privacy of student information. The most famous of those, of course, is the Family Educational Rights and Privacy Act, called FERPA, but there are others as well, including the Protection of Pupil Rights Amendments, the military recruiter provisions, and others. But administering and enforcing the law is only part of what we do. We also see one of our major missions as to raise awareness of the privacy challenges that the education community faces today in today's digital world. We provide substantial technical assistance to schools, school districts, states, and other education stakeholders. And then lastly, because compliance with the law is just the bare minimum that you need to do, we also promote a number of privacy and security best practices to help our education stakeholders and community better protect student privacy above and beyond compliance with the law. So very quickly, what is FERPA? Well, FERPA gives parents and eligible students a number of rights. For starters, it gives parents the right to access and seek to amend their children's education records. It protects any personally identifiable information, or PII, from education records from unauthorized disclosure. And it also requires written consent from the parent or the eligible student before any PII from those education records is shared with any third party, unless an exception applies. And so we'll talk about those in a moment. But there are two terms here that we need to define in order to better understand what the law actually requires. The first is personally identifiable information. I always joke, if you ask 10 privacy professionals to define personally identifiable information, you'll get at least 20 definitions. And it seems that every federal and state law that uses the term personally identifiable information defines it slightly differently. And FERPA is no different. It has its own definition. But you can really think of FERPA's definition of PII as falling into three categories. It includes direct identifiers, those data elements that have a one-to-one relationship to a specific individual. These can be things like name, social security number, student ID number, and so on, where each value for that data element uniquely corresponds to an individual. Beyond the direct identifiers, you also have indirect identifiers. These are pieces of information that have a many-to-one relationship to a student, but that significantly narrow down who it might be relating to. These are things like birth dates or certain demographic information. It may not uniquely identify the student, but it certainly narrows who the student might be. But then in addition to the direct and indirect identifiers, FERPA also includes a third category of information in its definition of personally identifiable information. And that's any other information that either by itself or in combination with other information is linked or linkable to a specific student that could allow a reasonable person in the school community to re-identify that student with any reasonable certainty. Now, there's a number of reasonables in that definition, which we can discuss during the Q&A later. But the key thing to take home here is that this other information could be any piece of information that provides enough to link the student or re-identify the student with other information that's available. That linkable component is really important here, because that means that there is no predetermined list of what is or is not considered personally identifiable information under FERPA. Any data element that's linked to the student could be personally identifiable information in the right context. So our responsibility when seeking to protect PII from student education records is to look at it from kind of a holistic perspective and make sure that we're not at any point releasing information that could be used to re-identify that student. And we have to look at each release separately for that to work. The other term that really needs definition to understand what FERPA protects is the definition of an education record. So an education record under the law is anything that's directly related to the students and that's maintained by or on behalf of an educational agency or institution. So at the end of the day, what FERPA protects is that personally identifiable information, the direct identifiers, the indirect identifiers, and all of that other linked or linkable contextual information that are resident in a student's education record, which is something that directly relates to the student and is maintained by the school or on behalf of the school. Those are the pieces of information that FERPA protects. And it protects them throughout its life cycle, whether it's stored at the school or transferred to the state educational authority, or even in certain cases transferred to the U.S. Department of Education or other organizations. FERPA would protect these data along the way. Now, I mentioned that FERPA requires written consent before any PII from education records can be shared or disclosed to a third party, unless an exception applies. And so FERPA has a number of exceptions to this consent requirement for a variety of reasons. There are a number of them that we're not going to go into today. These include things like the health and safety emergencies exception, the exception for directory information, there's exceptions for students in foster care, court subpoenas, and so on. There's a relatively long list of these exceptions that you can see in the regulations. The citation is on the slide here. But otherwise, if one of these exceptions does not apply, then you either need to obtain written consent to disclose it, or you must find a way to de-identify it by removing all of that PII, the direct, the indirect, and the linkable information before you release it or disclose it to a third party. Now, it's important to stress here that there is no research exception per se under FERPA. A lot of people ask this question. I frequently have people asking me, well, under FERPA's research exception, this is allowable. There is no research exception as kind of defined like there. Instead, there are a couple of exceptions to FERPA's consent requirement that can be used in support of research. Those are the studies exception and the audit and evaluation exception. And we'll talk about both of those today. But they do have limitations, and they're not as broad as what you may think of if you heard the term research exception, which doesn't exist under FERPA. So for starters, the studies exception. Well, this exception allows schools and school districts and state departments of education and so on to disclose PII from students' education records for certain studies that are being conducted for or on behalf of the school or school district or post-secondary institution. If the study is for one of three defined purposes, either for developing, validating, or administering a predictive test, to administer a student aid program, or to improve instruction. And the improve instruction is mostly what you see when you see studies being performed using PII from education records. But this essentially means improving instruction for or on behalf of the school or school district. So it's a lot narrower than you might think if you just heard studies, because it's for very narrowly defined purposes here. If you are going to utilize the studies exception to share student information for a study, then you need to have a written agreement in place with the recipient that is going to be performing the study, and that agreement has certain requirements. For starters, it has to specify both the purpose, the scope, and the duration of the study that is going to be performed. And that written agreement must also require the organization to only use the PII to meet the specific purpose of the study and not for any other purpose. The organization has to limit access to the PII to only those individuals with legitimate interests in performing the study, and they are obligated to destroy the PII upon completion of the study and to specify the time period in which that information will be destroyed. So all of those requirements have to be included in the written agreement between the school, school district, post-secondary institution, or State Department of Education and the organization that's going to be conducting the study. The other major exception that authorizes the disclosure of PII from students' education records without consent is FERPA's audit and evaluation exception. And this allows PII to be disclosed, again, without consent for certain audits or evaluations, and it allows it to be disclosed to authorized representatives of certain FERPA-permitted entities. Now, this includes at the federal level the Comptroller General of the U.S. over at GAO, the U.S. Attorney General, or the U.S. Secretary of Education, but it also includes any of the state or local educational authorities across the country that are properly identified by their state laws. So this includes typically your state departments of education. It includes your local school districts. These are all, generally speaking, considered to be educational authorities